Climate protection is one of the major challenges of modern law. This applies to all levels of law, national, European, international, and many different areas of law. Hence, the EU recently has taken a holistic approach on that matter, which encompasses different fields of economic and industrial activities. There are particularly significant impacts of climate protection law on energy law, which have become a decisive feature of the modern relationship between these two areas. Energy law and environmental law have become more and more linked to one another compared to former times, when the two areas of law had only comparatively few connecting points. Climate protection law is an issue both of environmental protection and of the supply with energy from different sources. It is an undisputed fact that environmental law and energy law both play an important role in the international and the domestic legal orders and have a significant impact on fundamental rights and individual interests. The growing influence of climate protection law makes it necessary to integrate it into the legal order, taking into account the other necessities and the basic decisions of energy law. Among those, the security of supply and the consumer interests are particularly relevant. Security and stability of energy supply is implicitly enshrined in different constitutional values and objectives, like the rights to life, to health, and personal freedom, as well as in the economic liberties. The current crisis has shown that quite clearly. In order to achieve the objectives which both energy law and environmental law are pursuing in an efficient and coordinated manner, differentiated solutions are required. This task is one of the main challenges of European energy law today, and this article wishes to highlight the structural baselines for finding a balanced approach. Environmental and energy law are both core policies of the Union according to the TFEU. They are marked by a sophisticated distribution of competences between the Union and the Member States, which also highlights the political delicacy of the topics. The repetition of competences in EU energy and environmental law can be found in the provisions on energy policy and on environmental policy in Articles 194, 191 and 192 of the treaty. As far as the subject matter is concerned, they are closely connected, although they contain different and specific competences for the Union under the principle of conferral, Article 5, paragraph 1 of the Treaty on the European Union. However, while Article 194 TFEU names a variety of goals for the energy policy of the Union, which are partly conflicting: functioning of the energy market, security of energy supply, energy efficiency, renewable energy, interconnection of networks. Environmental protection and the fight against climate change are firmly anchored in the energy policy of the European Union under Article 194, paragraph 1 TFEU. This adds to Article 191, paragraph 1 of the treaty, which makes combating climate change a goal of European law in the field of EU environmental policy. Among the other objectives of EU energy law are, as we have seen, the general market goal that is applicable to the energy sector too, and the particularly important objective to secure a sufficient and stable energy supply. The security of supply with energy is one of the central objectives of European energy policy under Article 194, paragraph 1 TFEU, and has always been recognized in the case law of the Court of Justice as one of the central security interests of the member states guaranteed by primary law. I only cite the case Campus Oil in this regard. The relationship between energy and environmental protection in European Union law, however, is not free from ambiguities. Despite the close interconnection in the treaty texts, it can even be described as a somewhat strained form of coexistence. This has mainly two reasons, which concern highly political questions. The first significant issue, which can cause an obstacle to an effective climate protection policy of the European Union, is the freedom of the member states to decide autonomously on their energy mix as set out in Article 194, paragraph 2, subparagraph 2 TFEU. This provision also covers the member states' decision to continue using fossil fuels or nuclear energy for their energy supply. Here, the treaty text reflects a deeply rooted wish of the member states to retain their freedom in determining the basic questions of their energy supply systems, and thus formulates a basic choice of EU primary law, which could only be altered by way of a treaty amendment. Whereas Article 194, paragraph 2, subparagraph 2 of the treaty does not bar the European Union from acting in this field and does not hinder it to take any climate protection measures altogether, it makes enacting laws significantly more difficult. Climate protection measures can be based on Article 192, paragraph 2, letter C of the treaty, which Article 194, paragraph 2, subparagraph 2, explicitly does not prejudice. According to this provision, which shows the close connection between the energy and the environmental policy, measures for an environmental protection that, I quote, significantly affect the choice of the energy mix remain possible, although they must be adopted by unanimity in the Council. This constitutional requirement has proven to be a considerable political obstacle. Even if it were desirable to have an effective union-wide energy legislation that would encompass ambitious climate protection measures, the use of the passerelle clause of Article 48, paragraph 7 of the Treaty on the European Union, leading to an extension of qualified majority voting in the Council in the area of Article 192, paragraph 2 of the Treaty, does not seem to be politically feasible at the moment. In any event, Article 194, paragraph 2, subparagraph 2 of the Treaty on the Functioning of the European Union does not contain an absolute prohibition of referring questions to EU law that both lie in the realm of environmental policy and affect the energy sector. Such measures can be based on Article 191 and 192, paragraph 1 of the treaty, and in the area of renewable energies, which is the most important field of application, also on Article 194, paragraph 1, letter C, and paragraph 2 of the treaty. While the legal basis of the amendment to the Emissions Trading Directive 2018-410 of the European Parliament and the Council of 14th March 2018 is thus Article 192, paragraph 1 of the treaty, the new Renewable Energy Directive 2018-2001 of the European Parliament and the Council of 11th December 2018, as well as the proposal for its amendment, Com Document 2021-557, is based on Article 194, paragraph 2 of the Treaty of the Functioning of the European Union. Hence, the right to determine the energy mix, according to Article 194, paragraph 2, subparagraph 2 of the treaty, is not to be interpreted as meaning to prohibit any influence of the Union on the choice of energy sources of the member states whatsoever, as the comparison with Article 192, paragraph 2, letter C of the treaty shows. However, it is not possible to set any specific mandatory targets for any given energy source under EU law, or to enact binding reduction targets at such a level that they would necessarily force member states to use these energy sources. This marks a significant impediment to an effective EU renewables policy. The second important baseline that is characterizing the relationship between EU energy and environmental law is the lack of any prevalence of one of the two areas. Of course, the cross-cutting nature of the environmental protection clause is stressed in Article 11 of the Treaty on the Functioning of the European Union and the corresponding principle in Article 37 of the Charter of Fundamental Rights. Nevertheless, EU primary law does not give a priority to environmental or climate protection over energy security. On the contrary, the restructuring of the energy supply systems due to the requirements of international climate protection law and the transition mechanisms have increasingly brought the problem of security of supply to the fore and made supplementary measures necessary. This is particularly true in times of energy crises. Thus, from a legal point of view, it is necessary to reach a convergence of the objectives as far as possible and strike a proper balance between them. This is one of the central legal problems currently determining both European and national energy policies, which both are trying to implement practical and affordable energy transition. Hence, a constant and differentiated weighing of the various objectives of energy law is unavoidable, which is particularly true in the fields that concern essential security interests in the area of supply. In the same manner, the internal market objective is on an equal primary law footing with relation to the climate protection objective, and hence an important legal argument for the promotion of market-based, efficient solutions in energy transition. This is true even if the European legislator has emphasized the climate protection goal in the recent secondary law updates of the so-called Clean Energy Package, which refers to the communication of the Commission Clean Energy for All Europeans, Com Document 2016-860, and the corresponding secondary law of 2018 and 2019. The same applies to the current major restructuring of the energy system at the European level, which is focusing primarily on climate protection. Here one can quote in particular the Regulation 2018-1999 on the governance of the Energy Union and climate action and the European Climate Law, the Regulation 2021-1119 of the European Parliament and of the Council of 30th June 2021, establishing the framework for achieving climate neutrality. However, improving the proper instrument for an internal market regulation is still an important task. Not only the effect of climate protection policy on the energy market, but also the guarantee of energy supply security is creating new challenges as far as the functioning of the internal market is concerned. It is in the overall interest of the coherence of EU energy law that no unnecessary conflicts between the objectives of climate protection and the efficiency of the internal market should be construed. This is even more important as the regulatory construction of the internal energy market by EU secondary law is becoming more and more complex. The difficulties that are marking the relationship between energy law and environmental law have led the Union to take measures that do not seamlessly fit in with the traditional approach based on the principles of supremacy and direct effect, the so-called old community method. With the increasing difficulties in the decision-making process of the Union, however, these approaches tend to put forward alternative ways of persuasive rather than compulsory rules in the toolbox of the Union in fields like energy and environmental law. An example of this rather significant innovation is the EU Governance Regulation 2018-1999 of 11th December 2018, as amended by the European Climate Law, the Regulation 2021-1119 of 30th June 2021. Both are based on Articles 194, paragraph 2 and 192, paragraph 1 of the Treaty on the Functioning of the European Union. It takes an atypical position in the traditional EU energy law and covers different areas of regulation concerning not only climate protection, but also the security of energy supply, the internal energy market, energy efficiency, decarbonization, and research and innovation. Its climate protection dimension, however, unfolds its most significant effects and contains the most extensive set of rules. The regulation is meant to increase the member states' actions and ambitions in taking measures in order to further climate protection in the Union and ultimately contribute to its climate neutrality. The design of the mechanisms, however, generate only a limited pressure vis-à-vis member states and their levels of ambition. It is therefore by no means clear if this new approach will be able to make a significant contribution to climate protection. It is characterized by weak legal enforcement and a reduced role of the Commission, which has few legally binding instruments for action. The 10-year integrated national energy and climate plans, which must remain within the framework of the common EU climate targets for the respective period, correspond with integrated monitoring tasks of the Commission. Union law thus does not set any binding individual member state targets. Quite similarly to the international law approach of the Paris Agreement, each member state determines its own targets, including a long-term strategy and thus its level of ambition according to parameters defined in the regulation. Retrograde steps compared to earlier voluntary commitments are not permissible. The integrated control system provides for reporting obligations to the Commission, assessment of progress by the Commission, and for recommendations according to Article 288, paragraph 5 of the Treaty on the Functioning of the European Union, which the member states have to duly take into account. Any deviations have to be justified. The role of the Commission is therefore limited and does not threaten the member states' freedom to determine their respective energy mix. The mere breach of the procedural requirements of the governance regulation is of course a violation of EU law, but it does not encompass a specific level of ambition. In the event of a lack of achievement of the common objectives, that is, a gap in ambition, the Commission can propose union measures, which are, however, essentially of a complementary nature, because they must build on the member states' planning. Apart from that, the governance regulation chiefly provides for a political monitoring of the governance system by the Council and Parliament. This is just as foreign to the classical union or former community method as the Commission's soft law control system. The idea of solidarity among the member states of the European Union is another feature that is becoming increasingly important in EU energy law and has recently been constitutionalized by the Court of Justice in the case C-848 of 19P Germany versus Poland. It is closely connected to the objectives of sincere cooperation and of energy security, but it goes beyond the latter insofar as it takes into account the interrelationship of the supply situations of the different member states. Article 194 of the treaty mentions solidarity in the context of EU energy policy. I quote, "in a spirit of solidarity between member states." But it does that with little guidance as to concrete obligations of the member states. Hence, the outlines of the Union law principle of solidarity are by no means clear, but still open to different viewpoints that find themselves, at least in part, heavily influenced by political considerations. In the field of energy law, the solidarity principle is more easily tangible because of its connection with the core objective of energy security. The two aspects taken together, therefore, form the basis of several legal acts of the European Union. They concern mostly the fields of network expansion and planning and the supply with gas. They have gained even more attention in times of crisis. In this context, one core problem lies in the fact that not all member states of the Union are equally connected to the internal market. There are so-called energy islands, especially in Eastern and Southwestern Europe, which are particularly vulnerable in terms of their security of supply. The repetition of competences in the field of energy network planning, however, is not favoring sweeping legislation by the Union, but leaves the member states with a considerable margin of appreciation for individual action, especially when questions of domestic planning are concerned. The Union has only limited competences for actual network planning. While some aspects can be based on the energy general competence of Article 194 of the treaty, others relate to provisions on trans-European networks in Articles 170 to 173 of the Treaty on the Functioning of the European Union. Article 194, paragraph 1, letter D, TFEU, contains an authorization for the interconnection of energy networks in different member states. It has a potential overlap with Article 171 of the treaty, but is to be understood as supporting all measures that improve the interconnection of energy networks and is not limited to planning law in the narrow sense. The central instrument for energy planning by the Union, including its aspects of security of supply and of solidarity at the European level, is the TENE regulation, based on Article 172 of the Treaty on the Functioning of the European Union. This is the regulation number 2022-869 of the European Parliament and the Council of 30th May 2022 on guidelines for trans-European energy infrastructure. A union-wide list drawn up by the Commission on the basis of proposals from the Member States defines projects of common interests, so-called PCIs, that are considered particularly necessary in order to fulfill these goals. It thus aims to end the fragmentation of the European electricity and gas markets by connecting all member states, diversifying the gas supply, and building up gas storage facilities. Even though the recent TEN-E regulation focuses primarily on sustainability, renewable energy and hydrogen infrastructure, securing energy supply has to remain an imperative objective in EU planning. Secondary legislation further establishes specific minimum infrastructure and supply standards. The most important legal act is Regulation 2017-1938 of the European Parliament and the Council of 25th October 2017 concerning measures to safeguard the security of gas supply as amended by Regulation 2022-1032 of the European Parliament and the Council of 29th June 2022 with regard to gas storage. This allows emergency supply from other countries of the Union in the event of a crisis. The recent rules on energy solidarity in the said regulation set up a rather complex but nevertheless paradigmatic system of mutual commitments of the member states to support each other in case of an emergency shortage of gas supply. It has become clear that the relationship between energy law and environmental law is highly intricate on the European level. The growing impact of climate protection law on energy law is a decisive feature of this development. But energy law too can give back an impetus or set limits on the means of climate protection. This makes a balanced approach indispensable, which, however, does not mean that the assertiveness of climate change law is weakened altogether. The EU legal framework of environmental and energy law allows and requires the use of all available instruments according to the principles of efficiency and proportionality. This is particularly true for the relationship between climate protection and energy security. Therefore, rather than an abstract relationship of hierarchy, which primary law does not establish, the concrete design of climate protection instruments in the field of energy supply is of a considerable importance and has to reflect the basic decisions of the various levels in both EU energy and environmental law. The legal framework must guarantee predictability and stability in order to protect the rights in these areas. A climate-friendly transformation of the energy system requires the acceptance in the states and the populations and has to safeguard the constitutional principles of fundamental rights protection. Energy security plays a vital role in this regard. Therefore, only a balanced approach can further European integration in climate change as well as in energy law, especially in times of crises. Even if in recent times the idea of cooperative action has been facing difficulties in Europe, this task in energy and environmental law cannot be solved by the states individually. Climate protection and energy security are responsibilities of the states that have the same value and form a necessary basis for the principle of solidarity. Secondary law has to reflect this complex relationship, as have the energy policies of the member states, in order to keep up mutual support and faithful cooperation. Only a secure supply can also be a sustainable one. If the member states abide by such a principled and balanced approach, the shortcomings of the distribution of competences may be alleviated and lead to an effective integrated energy and climate law and policy in the European Union.